everyone can at least hear me and see me preferably.
But we can't see you.
You can't, right. Well, let's just have a look.
Should be an option down on the bottom left to start video. There we go.
We can now.
Morning.
Yeah. Right, okay. That's probably not better, but there we go. So my name is John Murray. I'm a solicitor and I'm the inspector appointed by the Secretary of State to hold this inquiry and to determine the appeals. I will confirm details of appearances shortly, but I understand Officer Mr. Telford, a planning consultant, appears for the appellant, and Mr. Lighthead of Council appears for the local planning authority.
Yes, sir.
And just dealing with a few procedural matters largely relating to the fact that it's a virtual event. Now, as I said, I think it appears at the moment that I can only pin one face to the screen, but I think it needs the host to enable multi-pin, if that could be done. Don't worry if it can't, but I think that's the answer, because otherwise.
Try.
There might be a gallery view to type to.
Yes, I've got it on gallery view, but it just means that I've got lots of small images rather than.
Or on the actual speaker at the time.
Yes, so.
You can. You've got a switch to active speaker.
Sorry.
There's also a switch to active speaker. Can you see that on the screen?
No, this is the trouble. These things don't always look how you expect them to look to everybody else. Our speaker.
Just one procedural matter, please, if I may. I just need to advise or ask Martin if he wouldn't mind streaming it, please, Martin, if you're still there.
You don't mean me, do you?
No, I don't mean you, sorry, Martin. No, there's another chap in the council, Martin Derbyshire. Thank you very much. Okay, that's it. Thank you.
Sorry, I was having problems yesterday with connection, and it looks like that's going to continue today. So I've just had a message to say my internet connection is unstable. So that's a good start.
Yeah.
I asked whether the proceedings were being live streamed or recorded.
It's being live streamed.
Right. Does anybody have a problem? Any objection to that? Right. Okay. Let me know if that changes at any point. Now, if you could just make sure, as you would in a face-to-face event, that mobile phones are switched to silent, and unless you're speaking, can you also keep your microphone muted to avoid background noise, and except for the advocates, I know there's a position slightly different to the council because you've got several people in one room there, but apart from the advocates, if you could also make sure your camera is switched off unless you're actually speaking, just to avoid distraction. And obviously, it goes without saying, but it's even more important in virtual events to try and avoid more than one person speaking at a time. It becomes literally like bedlam after a while. But if you need to ask or interject or ask questions, then please use the raise hand function. There should be a reactions icon. Yes, there's a reactions icon at the bottom. So if you click on that, then you'll see the raise hand function. And then just lower your hand when you're finished. There is a screen sharing facility, but I'd rather avoid using that unless it's absolutely necessary. And if it's necessary to share documents, if they could be emailed to each party, including the planning inspectorate, using the Team E2 email address for the inspectorate. Now, bear in mind that not all parties may be familiar with digital events. It may look as if I'm not, but I have done quite a few. The technology may not be familiar to everybody, so just ask for your patience and understanding during the event. And if you lose connection, just as I did during the proceedings, or have any other concerns about connectivity, then please contact the council. If someone does lose connection, then I'll adjourn probably initially for 5 minutes. And in that time, just try to log back in as you did at the start, or contact the council. And the contact information is on the the joining instructions, including telephone number. If the problem persists, then a longer adjournment may be needed, and if it can't be resolved, we may have to adjourn to another day. Digital events, again, speaking from experience, can be quite demanding and tiring, so I do intend to have regular breaks anyway, but if you feel an adjournment is necessary at any time for any reason, then just let me know. It's obviously important in the interest of openness that before, during and after the event, I'm not left alone, as it were, with any particular party. So when we do adjourn, just please allow me to leave the Zoom meeting before you do. I will leave completely, so I can't see or hear anything that's being said, and I'll rejoin at the stated time. And please make sure you're back by the stated time. During adjournments, you'll be able to stay in the virtual meeting if you want to, the meeting room, and you can speak to each other or mute and turn off your cameras if you need to have a private conversation. If we adjourn in the middle of cross-examination of a witness, that witness mustn't communicate with any other member of their team during that adjournment. And similarly, witnesses can't be prompted by others whilst giving evidence. Preferably, no one should be in the same room at the same time, but at least if I can see what's going on in the room, that's not so bad. If the opposing advocate has any concerns at any stage about the possibility of a witness being prompted, just raise them. Sometimes I'm looking down, writing, rather than looking at what's going on the screen. I will, Mr. Telford, come back to the discussion about postponement, adjournment, etc. But I just want to first outline matters relating to the substance of the inquiry.
Thank you.
So the inquiry is into 2 appeals made by Mr. Robert Hadfield against 2 enforcement notices issued by North East Derbyshire Council on the 1st of November 2021 in respect of land at Brindwood House, Millthorpe Lane, Holmesfield, Derbyshire. And Appeal A, the notice subject to Appeal A, in that notice, the breach of planning control as alleged is without planning permission the material change of use of a building to use as a single dwelling house, use class C3, in the location shown filled purple on the plan attached to the notice, and that's thereafter called the building. And the requirements of the notice are to cease the use of the building as a dwelling house, remove from the land all fixtures and fittings installed inside the building to facilitate its use as a single dwelling house, and the period for compliance with the requirements is 4 months after the date on which the notice takes effect. And that appeal is proceeding on the grounds set out in section 174, subsection 2D of the 1990 Act, which is essentially that it was too late to take enforcement action. The relevant period is 4 years prior to the issue of the enforcement notice, so that takes us back to the 1st of November 2017. And then the notice, the subject of Appeal B, alleges, firstly, without planning permission, building operations comprising the erection of an L-shaped garage building in the approximate position shown filled blue on the attached plan. And secondly, without planning permission, building operations comprising the erection of a building in the approximate position shown filled green on the attached plan. And those are thereafter referred to as unauthorised buildings. And the requirements of the notice are: A, demolish the unauthorised buildings, including any half-standing, foul drainage connections and or buried tanks, and remove all materials arising from their demolition from the land. And then reseed the ground following compliance with step A with a general agricultural grass seed mix, EMSGate, or is it EMSGate, EM1 or similar. The period for compliance with the requirements is 3 months after the date on which the notice takes effect in respect of step A, and 4 months in respect of step B. Now that appeal is proceeding on the grounds set out in section 174 2A, C and F, namely that planning permission should be granted, but that the matters alleged don't constitute a breach of planning control anyway, and finally that the requirements of the notice are excessive. So I'll just obviously make sure I've got the right people before me. So for the appellant, obviously, is Mr. Telford, planning consultant. In terms of witnesses, as I say, we'll come back to this question of what's going to happen over the next day or so. But in terms of witnesses, you told me that you'll be giving evidence, and that 3 others, and I'm assuming that's everybody except Mr. Steele, who you say is abroad anyway.
is, yeah, I referred to Mr. Steele trying to get in virtually, which I will do certainly, and I'm again trying today. The time difference isn't an issue. It's just a case of trying to get in virtually. Mr. Hadfield is available if the inquiry proceeds. The other two will not give evidence simply because I don't think their statutory declarations have actually been challenged, and they're submitted to be taken as read. But again, if they are required, they will give that evidence again on oath if required.
Right. Well, before we go any further, Mr. Lighthead, can I just check whether that's correct, that Ms. Harris and Mr. Atkinson's evidence is not challenged?
That is not correct. So the council's case is that the building wasn't in an independent dwelling for those years. Both those witnesses are arguing that it was. That evidence most certainly has been challenged.
Right, thank you.
So I think what they say in their statement was that they were simply aware of it being occupied, and Tyler Harris is actually the occupant. I don't think she's claiming anything other than that and stating anything other than that, nor is the other statutory declaration. So I don't think they're arguing that. I think they're just stating a fact that they were aware of it being occupied. I don't think they're involved in the argument as to whether that occupation was lawful or otherwise.
Yes, I mean, I obviously don't get too bogged down in this at the moment. Obviously, Ms. Harris can only speak to her sort of recent experience. I think it may be, I shouldn't speak for Mr. Lighthead, but as far as Mr. Atkinson is concerned, Mr. Lighthead may want to explore the extent to which what Mr. Atkinson says actually demonstrates anything in particular.
I understand that. I don't argue against that in any way at all. I was just simply trying to interpret what they were saying in their statutory declarations. If Mr. Atkinson is required, then I'll make that known now.
Mr. Lighthead, as far as that's concerned, obviously, it's for you how you want to present your case. As far as you're concerned, it is necessary for you to challenge what's being said in those statutory declarations rather than simply comment on the weight or cogency of their evidence.
Well, with respect to it, it seems to me it's the other way around. It's for the appellant to present its case as it sees fit.
Yes.
As with any witness in any court proceeding or any inquiry who produces a statement and then doesn't make themselves available for cross-examination, inevitably an application will submission will be made to place little weight on that. The nature of Ms. Tyler's, assuming Ms. Tyler is living there, the nature of how she's come to be living there, the circumstances of whether it's an independent dwelling or whether she's living there in some other way, are highly relevant. But it is entirely for Mr. Telford how he wishes to present his case.
All right, so that's the position, Mr. Telford. If you choose not to call Ms. Harris and Mr. Atkinson, then Mr. Lighthead will make submissions on the what I can take from their evidence.
I understand that. Yes, thank you.
Right. And have you are you able to make a decision on that now, whether you will wish to call them?
I can't. I would need to speak to someone first before I do that.
Okay. Thank you very much. And for the council, we have Mr. Lighthead, and I understand you have just two witnesses, Joanne Edwards, Enforcement Officer, and Julian Hawley, Principal Planning Enforcement Officer. Is that correct?
That's correct, sir. Thank you.
Thank you. And Are there any others at this stage who know that they will want to speak? I won't hold you to it one way or the other. In other words, if you change your mind and decide you don't want to speak, I won't make you. And if you don't tell me at this point, we can change your mind and say later that you'd like to speak.
My name is, can you hear me all right?
Yes, I can, yes.
Hi there, my name is Bryony Barrett from IDA Planning.
Brian, yes. It's not terribly clear, but I can hear you. Bryony Barrett.
Yes, Bryony Barrett from IDA Planning. We submitted representations as part of the appeal on behalf of Mrs. Sally Shaw and her family, who are neighbours of the site. We're mainly here in just an observational capacity, but I guess I would prefer to reserve the right to speak if I think necessary. Thank you.
Thank you.
So, and you'll see they put in written submissions.
Yes. And you've seen those, Mr. Telford?
Yes, I have, sir. Yes, thank you.
Thank you very much. Now, I have a copy of the council's notification letter regarding the date and venue for the inquiry and the list of persons notified. And there were two letters in response to the original notification of the appeals, namely from IBA Planning on behalf of Mr. Marples, Mrs. Marples, Mr. Shaw and Mrs. Marples Shaw, all of New Road, Millthorpe. That was the 18th of February 2022. And a letter from Martin Peace of Woodland View, Millthorpe Lane, Holmesfield. That was undated but received on the 1st of February 2022. I take it everybody has copies of those?
Yes, sir.
Good. And I'm not aware of any other written representations. Right. I did send out a pre-inquiry note, which obviously the main parties have got, as well as IBA Planning. And in that note, I set out the list of plans that I have on file. So obviously I've got the notice, the plans attached to the enforcement notices. And then in relation to appeal B, I have plans showing what's referred to as the outbuilding and the garage. Is that the list that I included in the pre-inquiry notes complete and accurate?
Yes, sir.
Good.
So, yeah.
Thank you. Now, as far as those plans are concerned, may I just clarify a couple of points. First, for you, Mr. Lighthead, the outbuilding shown coloured green on the enforcement notice in respect of appeal B is unfinished. But is the council happy that what has been built so far accords with the plans that I've just referred to, particularly in relation to the footprint, eaves height and ridge height?
Thank you, sir. I know this is inquiry, but it might be easier if Mr. Hawley speaks to you directly on that.
Yes.
Yeah, it appears to be correct, although we've not actually gone out and verified the information on the plans exactly. So we've not taken physical measurements of the heights of the building.
Yeah.
But in terms of their appearance, they appear to be correct.
And Mr. Telford, as far as that's concerned, I'm assuming you say those plans are accurate, but the issue is not that the buildings don't, when measured literally from the ground adjacent to the walls, don't exceed the tolerances in the GPDO, but you say that they should be measured from elsewhere. So whether or not they're entirely accurate, they do exceed, not on the face of things, exceed the limits in the GPDO.
Yes, my argument has been that the ground level is a different point from which the height should be measured. As far as the buildings are concerned, they were manufactured to those plans off-site, and as far as I know, and as far as my client knows, they're being built in accordance with what he ordered and the design that he got.
I'm just trying to bottom out whether I'm going to need to be faffing around with measurements on site. That's all really.
We haven't disputed, and we don't dispute the council's measurements that they're putting forward as part of the case, certainly.
No, but I think I saw some measurements that were slightly different from the ones that are shown on the plan. That's why I'm asking. But in any event, as I say, that whatever the measurements are, they're greater than what's specified in the DPDM.
Yes, the measurements are above, irrespective of the ground level argument, they are above the tolerances, yes.
Yeah. Thank you. And the same question really in relation to what was called the garage building, the blue building on the plan, whether that has been, is it accepted that's been constructed in accordance with the plans?
Again, the same applies. We've not actually been out to check and taken physical measurements of it, but it appears to be correct in terms of its overall design and appearance.
Is this the former garage, sir?
This is a
no, the new garage.
Oh, the new garage. Sorry,
Yeah.
yes, okay. It's the same situation.
Yeah. Thank you. Now, I mentioned a couple of things in the the pre-inquiry note that I hadn't got, but I've noticed one or two others. One was there's the planning contravention notice, which is core document 3, but I haven't got the plan that was associated with that planning contravention notice. So if that could be emailed to the planning special case officer, the team E2 email address, that would be helpful. And similarly, but in the pre-inquiry note, I also asked for a copy of the plan attached to Colin Steele's statutory declaration. I've only got the text, I haven't got the plan. Okay. So if that could be emailed as well.
So that was sent to the team E2 last week.
Was it? Oh well,
yeah.
I'll have to double check that. I haven't.
Essentially, it's the same plan that was submitted with the LDC application.
Yes.
So there was no separate plan submitted with the signed declaration. The signed declaration on both the LDC and the enforcement notice are the same, and they both refer to the LDC red line plan.
Sorry. So the plan attached to the planning contravention notice is the same as the LDC plan?
No, sorry, they're two separate matters. So I'll forward the planning contravention notice plan to you now.
Right. But the Colin Steele's plan is the same as the LDC plan?
Correct.
Thank you. Right. Okay. So yes, I have got that. Thank you. Just turning to proofs of evidence. Now, as far as the appellant's concerned, I don't have formal proofs as such, but I do have Mr. Telford's statement for Appeal A and with Appendix A, Mr. Telford's supplementary statement for Appeal A, which also has an appendix. That's the Lawful Development Certificate Delegation Report, which is also core document 8. Colin Steele's statutory declaration, the 1st of July 2022. Robert Hadfield's declaration of 16th February 2020. I've got those dates right. That doesn't.
No, that's...
Yeah, I might have put a.
It does say 2020. It is 2022, sir, but it was written on by hand when it was being signed, but I've just noticed that myself, but it certainly was just done this year. It wouldn't have been done in 2020 because it wasn't required at that time.
Yeah. Right, I hadn't noticed that before. So Mr. Hadfield, are you saying that should be 2022?
Should say, yes, and yes.
I mean, I usually for a month or two still after January, still right the previous year, but I don't need to keep it going for a year and a bit.
Yeah, I don't think I could use that as an argument at all.
And then Tyler Harris's declaration of the 16th of February 2022, and I'll call it a statement of Richard Atkinson of the 16th of February 2022. As I say, that doesn't really meet the tests of a statutory declaration as such.
I understand that. Yeah.
And then I have your statement, Mr. Telford, grounds and facts for appeal B, including the enforcement delegation report and plans for the garage and outbuilding. And then for the council, I have a proof from Mr. Hawley, and there are 11 core documents. And I also have a summary from Mr. Hawley, and then a separate proof from Joanne Edwards. No summary, but it's a short proof in any event. I take it all the parties have copies of those.
Yes, sir.
Yes.
Good, thank you. So I've read all of those, and I'm happy for them to be taken largely as read, but I'll come back to that before each witness gives evidence, and obviously it's up to you how you want to present your evidence. And of course, in any event, cross-examination can take place in respect of the full content of proofs. I was going to say I haven't received a statement of common ground, but I did see an email yesterday talking about a statement of common ground. Is one likely to materialise soon?
I did send it back to Julian yesterday, sir, and I agreed with it, apart from one item, which was really not a dispute, but it was just an additional paragraph I suggested being included.
So will that be submitted?
It will be, yes, sir. I'll do that as soon as possible.
Thank you.
A chance to incorporate Mr. Telford's comments yet. So as soon as I'm able to, I'll forward it.
Thank you. Now, as is usual, where we have a ground D appeal, claiming that matters are immune from enforcement action, evidence is taken on oath. And as in a court of law, where evidence is given on oath, a failure to tell the truth can result in a prosecution for perjury and a penalty of up to 2 years imprisonment. I believe hard labour has been abolished. If my decision is based on false evidence, that may also render the decision unsafe, so it has other practical consequences. But are all witnesses content to affirm? That's really the only practical way of doing it when we have a virtual inquiry, but it has exactly the same effect in law as evidence given when sworn on a holy book. Yes, sir.
So I note that several witnesses weren't here to say that. May I respectfully suggest that as each witness gives evidence,
yes,
you draw it to their attention.
Yes. They were prepared to swear statutory declarations, but yes, you're quite. Please remind if I get in the heat of the moment. I'm not proud. I'm not. I don't mind being reminded of things that I've forgotten. Thank you. Now, one thing I should say on that score, Mr. Telford, just in case it looks like you're being treated differently, where I have a witness who is also the advocate, I tend to ask them to take the oath before they make their opening submissions, because it's not always easy to draw a line between what is an opening submission, what is actual evidence. Obviously, I wouldn't do that with Mr. Lighthead, but that's the reason for that. Now, perhaps this is the point at which to talk about the what's going to happen in terms of whether we do proceed.
So there's one point, if I may raise it beforehand. Apologies to Mr. Telford, he hasn't been made aware of this, and it may just affect what's decided on the running order. It seems to me that cross-examination is clearly needed on the ground D appeal. Yeah. As you'll be aware, so there is now more flexibility on appeal as to what can be heard via roundtable. There's some quite technical evidence, for instance, on curtilage and on height measurements, and the council's of the view that could be dealt with via a roundtable discussion would greatly speed things up and could be more targeted. rather than laboriously going through everything in cross-examination. Now, Mr. Telford may have a different view, and I've not run this by him yet. And of course, you, sir, may have a strong view as well.
Before I ask Mr. Telford his view on that, perhaps I can say something, because I saw an email from the council late yesterday. It arrived slightly earlier than I'd seen it. My connection had dropped out, so I wasn't aware that it arrived until quite late today. So just as I was clocking off, effectively, I saw an email saying, can we deal with Appeal B by a round table? And I kind of hurriedly did a response saying no. But that was largely because, how round table sessions effectively a hearing, but it means preparing in a different way. Obviously, I have to direct the thing and not make sure I've got my questions worked out and so on. And I hadn't done that, and I wasn't going to be able to do that last night. But it occurred to me, thinking about it, probably at 3 o'clock in the morning when I was woken by a clap of thunder, which could have been the voice of God for all I know. But anyway, it occurred to me that we may be able to go one stage further. I want to explore that with you, and that is that, as Mr. Telford made clear in his first request for a postponement, the appeal was submitted on the basis that it will be dealt with through written representations. It is only Appeal A and the ground D on Appeal A which has led to an oral event, and it is only the need for evidence to be given on oath which has led to that being an inquiry rather than the hearing. But I wondered whether the parties would be happy for me to actually determine Appeal B, on the basis of written representations, subject to the ability to make submissions on that at the end, those representations at the end of the inquiry, not with extra evidence, but commenting on the written evidence that I've already got. If that is the case, then that greatly speeds. Round table sessions don't always speed things up as much as you might hope. Everybody assumes that they will, but it doesn't always work out like that. So that was just a thought, and I'm open to. I haven't obviously made up my mind on that.
So to check I understand this, what you're suggesting is that we have the Appeal A, the ground D, via on cross examination.
Yes.
Third parties can say whatever they want to say.
Yes.
And then Appeal B will proceed by written reps, but with oral closing submissions.
That was what I was thinking. I mean, as I say, I don't know how happy you would be with that, but if it hadn't been, if we didn't have Appeal A, I would be just dealing with this on the basis of written reps. There are often questions in any written reps cases. I often think I'd quite like to ask this, but we just have to get by on the basis of the written representations. If you're content, Mr. Telford, with the written representation you've made, and similarly the council, then I don't see any particular reason why I can't proceed on that basis. But I think it would be unrealistic to say that you can't make any comment about that in closing submissions.
So I think before a decision is made on that, I think just having 5 minutes to be able to take instructions on that away from the camera would be appreciated.
That's fine. So will.
Yeah. So could I just comment on that? It might help those discussions. We started off with both appeals. There were two separate appeals.
Yeah.
Whilst they're being referred to as obviously one, there were two separate appeals, both written representations. Certainly one appeal could be separated out again and dealt with by written representations. And from our point of view, we were happy with that in the first place, as were the council, because we'd both submitted our evidence for that. It was only when the council raised the issue of Colin Steele's statutory declaration that the inspectorate decided, in fact, it should all be heard at an inquiry. Yeah. So we'd have no objection to it being done in that way.
Yeah. Right.
There may be an issue with the regulations. I have to say, I've not been in a position before where appeals have been separated out again, and once the decision is made to join, whether any man may cast asunder.
I'm not suggesting, I mean, I think Mr. Telford there went sort of one stage further in terms of separating that. I'm not talking about formally separating them out, but whilst this is still an inquiry, if I turned up to an inquiry and both parties said to me, actually, there's nothing else I want to say, I'm happy to rely on my written representations, and the other side said the same thing, well, I don't see why I couldn't proceed on that basis unless I really needed to ask lots more questions. So I'm not suggesting that the appeals are separated out. I'm suggesting that there's still, the inquiry relates to both appeals, but if you're happy to rely on written reps, then I could determine it on that basis. I don't think there's anything in the regulations to prevent that, and we are encouraged to be creative nowadays in terms of how we deal with appeals and consider whether some elements can be dealt with either through roundtable sessions or by written reps. But Mr. Lighthead, as I said earlier, I'm not adverse to being put right. If I'm wrong about that, please say so.
It would take me a little time to check, I have to say. So it's an unusual situation. It's not one I've encountered before. Well, I've got Westlaw open.
It's a bit like, put it this way: if Mr. Telford called the witness and just said, I mean, there may be, called the witness and just said, you know, we have your proof. Do you confirm that it's true? No further questions. And you said, I have no cross-examination. Then that's effectively where we'd be. I'd be relying on the on the written representations, albeit backed up by confirmation on oath that it's true.
Yeah, that is true. I need to think about my own professional responsibility. Whether I would have thought a short discussion,
yes,
on each ground might be preferable to having a straight written reps.
Yeah,
short round table session on a couple of points. I mean, there are
I have put it this way. One of the reasons why I said no straight away yesterday was because I haven't thought about what those short couple of points would be, as opposed to.
I mean, it could be. Indeed, I mean, the appellant, it seems to be in some difficulty. They've, you know, if you look at the ground A appeal, they've not suggested it's not inappropriate development. They've not suggested there's any very special circumstances. I mean, really, it's game over for them.
Well, obviously, there's that, you know, again, that in itself is a matter for submissions. I don't. I'm certainly not aware that there's a particular dispute about whether it's inappropriate. This is why I asked Mr. Telford first of all really about whether he prepared for that, and the indication I got was that the understanding that I formed was that he'd be happy with representations.
So can I just throw something else in? Can I just throw something else in? If it had been written representations, the appellant would have had the chance to make comments on the council's submission. In an inquiry, the appellant's opportunity to comment on the council's submission would have been, that opportunity would have been taken then. On the written representations, the appellant hasn't had the opportunity to comment on the council's submission.
Yeah, okay, well, that's I talked about the opportunity to comment in terms of closing submissions, but that's not necessarily the same thing, because as I say, that wouldn't involve additional evidence as such in terms of commentary. So that is a problem. That's why I asked you, Mr. Telford, whether you were happy with that. So that may be the particular fly in the ointment, really. But just so you know where I stand on a point that Mr. Lighthead just made. I often think it's useful for me to say what I'm thinking at any particular point in time, just so that you've got an opportunity to address that, I'd like to make it clear that when I say these things, I haven't necessarily made up my mind. I haven't closed my mind to other arguments, but I think it's useful to know what points you've got to address. And as far as very special circumstances are concerned, there's been that's not been articulated, but there's been reference to what I might call a fallback position, and there's been reference to the materials that have been used in the construction of the building and so on. I'm not making any comment about whether that amounts to very special circumstances, but those are the sorts of things that that I would have to take account of. Now, Mr. Lighthead, in view of what's just been said by Mr. Telford about the opportunity to comment, does that just bring you back to your roundtable suggestion, or is there anything further you want to think about in terms of whether
Forgive me, so I'm just checking the Town and Country Planning Inquiries Procedure England rules, which seems to be the right place to look. The inspector, Rule 12, Rule 1512, the inspector may take into account any written representation or evidence or any other document received by him from any person before an inquiry opens or during the inquiry, provided that he discloses it at the inquiry. I mean, that's not designed as a submission from the parties. You can refuse to permit the giving or production of evidence or cross-examination of giving evidence or presentation of any other matter, which you so consider to be irrelevant or repetitious. But where you refuse to permit the giving of oral evidence, the person wishing to give the evidence may submit to amend evidence or other matter in writing before the close of the inquiry. I think the long and the short of it is that, as it is an inquiry, if someone wants to say something, unless you've got a good reason to stop them saying it, if they don't want to say anything, that's another matter, I think. I would have thought both parties would want to say things, but I need to take instructions.
All right. Okay. Well, I will adjourn. And unless you said, I think you said 5 minutes. Shall I make it 10 minutes?
Okay.
Thank you, sir.
Thank you, sir.
So I will leave the meeting and rejoin. So I'll adjourn and let's call it until 5 to 11. Thank you very much.
Thank you.
So, Mr. Knighthead, where have we got to?
Thank you. So it would take me a little time to go through regulations and so on. As to the various options, we don't think written reps is appropriate, and it's not clear to me that that's possible now to do that under the regulations. But I'd need some time to research that. As to the other options, the council's preference would be to have just a sort of roundtable discussion. What I didn't realise yesterday, what we didn't realise yesterday, was the difficulty that would pose to you in preparing to chair that. The other two options are to have a normal cross-examination, like a normal inquiry. That seems to me, on this particular evidence, on all that detailed stuff on curtilage and maps, particularly over Zoom, it is just going to be unnecessarily laborious. What we could do in my submission is to have a normal, if we can't have a roundtable discussion, to have a normal inquiry where the evidence is basically taken as read, but examination in chief is restricted to just a few key points that the witness wants to get across, and cross-examination is again restricted to just a small number of points, with most of the evidence being taken as read. I think that seems to me that would be fair to both parties.
I agree. The difficulty is knowing in advance what those those limited matters are going to be.
Well, that would be a matter for the advocates, in the same way that any cross-examination or any evidence chief is always that's never agreed in advance, unless the inspector says, well, I want to cover a particular point. I have to say, I've never had an inspector say, I mean, the inspector set out the main issues, and then it'd be for the parties to work within that. As to closing submissions, because it's a potentially one-day inquiry, I've made a start on writing closing submissions. It doesn't much matter to the council whether I end up doing bits of that orally or bits of that in writing. But obviously, if there are to be closing submissions, some time will be needed to prepare those, whether they're done tomorrow morning or how that works. We'll leave to you. But Mr. Telford will no doubt want to.
Well, can I just, so that I know what we're dealing with, can I just ask, is everybody available tomorrow? I am available tomorrow.
Yes, sir. Yeah.
Yes, I am, sir.
Good, that helps. So that being the case, it's possible that we could effectively deal with appeal A during the course of today. That depends on Mr. Telford's witnesses available. That's another variable in this. He said he needs to check who would be available, which would give me the opportunity this evening to prepare for a roundtable session. I mean, from a purely personal point of view, my preference would be for effectively evidence, as far as evidence chief is concerned, for proofs to be taken as read, and then simply so Mr. Telford, for example, has indicated that he'd had no opportunity to comment on council's evidence, so his evidence in chief could be just limited to what he needs to comment on in the council's evidence. And if you were able to limit your cross-examination to essential points, then that's great. But I just don't know. I can't tell how that's going to go. I don't know what you think is essential. I don't know what Mr. Telford thinks is essential. I could prepare for a roundtable session tomorrow. I'm also hesitating slightly because, to some extent, it depends what's in the statement of common ground, which I haven't yet seen. So there are clearly, I have some things in mind that I would want to focus on, but I haven't thought about exactly the issues that I'd want to cover at a roundtable session. So
is it convenient at this stage to say what I wanted to say about an adjournment?
Well, yes.
the adjournment may give you the opportunity to look at that.
Yes, well, I just wanted to talk through these various options because that might affect what you wanted to say about an adjournment.
Yeah, okay.
All right, thank you. Yes. So
Oh, you want me to say? Sorry. Sir, I previously set out the reasons why I asked initially for a postponement, and I understood that, but you wanted to open and get matters like this sorted out first. So obviously I'm making an application to adjourn the inquiry so that we can take it further then. The emails outlined why I've not been able to liaise with the appellant or his lawyers and complete the necessary paperwork regarding the appeal. That's why this statement of common ground was late. In 51 years in local government and private practice, I've never come across such circumstances that have caused the issues with this appeal. And I hope that I nor anyone present ever comes across such circumstances again. As a result, I've not had the opportunity to discuss all the papers sufficiently with the appellant and fully examine and be instructed on all the issues raised by the council and the interested parties. The appellant and his witnesses are unprepared as a result of not being fully informed to take part in these proceedings. The adjournment will allow full witness statements to be prepared and a bundle submitted, not raising new evidence, but responding to the council's statements of case and supporting documents. Matters raised therein require detailed examination, clarification, and following that detailed consideration, it may be possible to speed up the inquiry. One matter that is additional information is a matter for my client that came to light on Friday last, and I've drawn the council's attention to it, was that he received a council tax demand for Brynwood Lodge as a dwelling house. That demand, no doubt, as a result of the discussions between the enforcement officer and the council tax department, seeks back payments for council tax periods between the 1st of January 2012 and the 23rd of August 2022 in the sum of £17,429.06. In seeking an adjournment solely as a result of the difficulties I've outlined, the appellant doesn't seek to gain any financial or other benefit from a delay. Fully appreciate the adjournment will cause inconvenience and possibly additional costs being incurred, so I don't make this request lightly. However, in the interest of fairness, the appellant should have the opportunity to make his case, consider all matters and the advice is offered, as well as dealing with any issues that may be raised in cross-examination. So I refer to on the issue of fairness, and you'll know this better than I do, I'm sure, but Lord Justice Nuji, in a case of Bilter against Traditional Finance Services. In fact, it was an inquiry, a Court of Appeal inquiry raised by number 5 chambers. He says fairness involves fairness to both parties, but inconvenience to the other party is not a relevant countervailing factor and is usually not a reason for refusing an adjournment. I note the concerns of the council in the email from Mr. Purcell about the timing of this request, but I must state I was in no position to make the request any earlier than I did. And whilst he believed that nothing had changed for me for some time to avoid the request being made earlier, I can assure him that my circumstances unfortunately changed radically during the last 18 weeks. I don't seek an indefinite adjournment, and my client wishes to bring the disturbance in his property to an end. Having taken advice, I will be available to resume the inquiry face-to-face and advise my client fully on the council's case in response to his appeals within 3 weeks. In the meantime, having noted the council's wish to cross-examine Mr. Steele on his statutory declaration, I will endeavour to have him virtually available from Thailand for the resumed inquiry, and I make this request accordingly.
If Mr. Telford's finished, may I respond to that, please?
Yes, certainly.
So the first point to make, and Mr. Telford may not be aware of this, but it's a public inquiry. The council's aware of the reasons for the adjournment. It is a public inquiry. There are others in this room, and perhaps others watching online who aren't aware. And I wonder whether Mr. Telford thinks it's appropriate, first of all, that those reasons are made public, or if he'd prefer to keep them private.
Sir, I think you were the one that said that you wanted to keep them confidential.
Well, it's a matter for you really, but I was anxious that we didn't air sensitive personal information that with you without you being happy with it. I mean, it could be sort of summarised on the basis that you have very serious health issues within your family that you've had to deal with, which has prevented you from from working effectively. That's your case. If you want to add more detail to that, then that's fine. That's a matter for you. But I didn't want things to just come out in the open without your being content with that.
No, sir. I've worked, I think, in the last 18 weeks. I've worked on a very limited basis. The situation is that I've not been able to leave my wife on her own for health reasons and also for psychological reasons related to that. And that is what has really delayed me in being able to discuss the matters in full with my clients. Hopefully that serious treatment is coming to an end. Radiotherapy is the next course, but that doesn't have the effects that chemotherapy has had. So it has not been possible for me to advise my clients fully. It's no problem caused by my clients seeking to delay or disrupt matters. It's purely the fact that they've not been able to be advised fully.
Thank you, Mr. Telford. That's the first point, and the council has said in its written communication with the inspector and with you how sorry we are, and that we wish your wife and indeed you well. The difficulty with this appeal, and you're already aware a cost application may follow. These issues are not new issues. They've been known to you for some time. Numerous deadlines have been missed, and then with less than a week before the inquiry, at that point, you've asked to adjourn. The council is ready and willing to go now, and there's no reason from the council's point of view why the inquiry cannot proceed today. That's the first point. The second point is this, which is that the appellant didn't provide any proofs or any other evidence by the deadline. In an email last week, you said to the inspector that no further evidence would be produced. Now you're saying, well, further evidence will be produced, but it won't be new evidence. It will just be new evidence on things that aren't new. It seems to me that that is going to take additional time and additional expense. The council will need to consider that evidence and consider whether it now needs to put in rebuttal evidence of its own. If you are to put in new evidence, it will only be fair for the council to have the opportunity to respond to that in the normal way. As to council tax payments, I can speak to the council on a limited extent for that. It's not part of this inquiry. It's not relevant to the inquiry, and I'm not instructed on that. My understanding of the situation is that your client has effectively told the council that is liable for council tax since 2012. If it's an independent dwelling, he's liable for council tax. So he's effectively written to the council and said, it's an independent dwelling. We've been liable for council tax since 2012, please bill us. Now, that doesn't mean to say that the council has made a judgment. In fact, the council doesn't accept it's an independent dwelling. But if someone phones the council and says, effectively, look at me, I'm liable for council tax, they can't really be surprised if they get a whopping council tax bill.
So just on that, I raised council tax simply because the council said that no evidence had been given to support the the claim that it's a dwelling, because no council tax records had been produced. We didn't instigate this. My client did not ring the council and say I'm liable for council tax since 2012. That in fact came when he asked somebody from the council to come and In fact, he didn't ask from the council, he asked the valuation office to come and put a value or a banding on his property or the lodge. So it wasn't as a request from my client to the Council Tax Revenues Department. The only contact he had, with nothing specific, no size of property, no dates, he asked them to come and put a valuation on that property for council tax purposes, but that's as far as it went. As far as the council and the Council Tax Department are concerned, I've seen correspondence, and I think it's been circulated from Julian Hawley to the Council Tax Department asking questions regarding the property.
So if I may, forgive me, I'm sure you don't want some constant back and forward, but just 2 points. I think my learned friend's confusing two issues. The issue when the council in this inquiry raised the issue of council tax payments, that was simply to evidence whether or not the dwelling is an independent dwelling house. If a dwelling is an independent dwelling house, you'd expect things like bank statements, council tax, separate bin collections, being on the electoral roll, a separate postal address. All that would be evidence of an independent dwelling house. So the reference to council tax payments was simply an issue to help the appellant to evidence his case. If he'd been paying council tax since 2012, that the council probably at that point would say, okay, we accept it's an independent dwelling. The issue over whether council tax is now due is an entirely separate matter from the proceedings beforehand. You're not being asked, and it wouldn't be proper in my submission, sir, for you to make a finding of that. Now, of course, if the appellant loses his ground D appeal, he can go back to the council and say, look, I'm not liable for council tax. That's going to be a very strong submission for that. If he wins his ground D appeal, then the council may well pursue him for council tax. And it sounds like they are, but the appeal procedure for that is totally separate from these proceedings.
So I only raised that because it was additional information, because in the comment I made before, in that no new information will be put forward. My client is aware that if he fails on ground D, that he will in fact respond back to the Council Tax Department. I only raise it as a matter that has arisen, and I know the Enforcement Department were involved with the Council Tax Department over Colin Stale's occupation of the property. But I raised that purely as an aside. I didn't want it to cloud the issue of the request for an adjournment.
All right. I mean, as far as council tax is concerned, it's something that's nearly always referred to in proceedings of this nature. But the fact that somebody doesn't pay council tax or hasn't paid council tax doesn't prove that they weren't there. But similarly, the fact that the council requests the payment of council doesn't prove that they were, because the Council Tax Department aren't responsible for resolving that issue in the planning context. So it's of very limited significance, put it that way, in these appeals. Mr. Lighthead referred to your indication that you would want to put in, you said not new evidence, but additional evidence. If it's not new, what purpose does it serve? If it's not adding to anything?
The council may wish to comment on, they wouldn't have had the opportunity if it had been a written appeal. The appellant's comments on the council statement are final. But if we comment on the council's case, which my client wishes to do, then he would, in fact, at an inquiry, he would have, or if you commented on it at the hearing, the council would have had a chance to respond. If it's a written appeal, they would still reserve the right to comment on the council's statement.
Now, you said you'd be available from 3 weeks, but you've also said that you'd want to put in additional witness statements, as you put it. Obviously, as Mr. Lighthead indicated, if that happened, the council needs time to actually consider that. It wouldn't necessarily be the case that they would have to put in rebuttal evidence, because they can rebut it during the course of the inquiry, possibly make the inquiry long by doing it that way. But what I'm saying is 3 weeks, there's a lot to happen within this isn't going to be resumed within 3 weeks if there's going to be further evidence.
So the point I made about 3 weeks was my availability, not that it could be done in 3 weeks. It was just, I think in your email, and I think the council had indicated, I think it was Mr. Purcell said, I hadn't given a time as to when I would be available. All I'm saying is from 3 weeks onwards, I will be available.
Mr. Lighthead, as far as further evidence is concerned, if the appellant isn't allowed to put in any further written evidence, that won't prevent them commenting orally at the inquiry on what's been said in your proofs. So often we're faced with this difficulty about which is the most efficient way of dealing with this. Is it better to have some further written evidence in the hope that that will shorten proceedings at the inquiry, or just deal with it on the hoof at the inquiry?
Well, so that's if it's dealt with as an inquiry, the inquiry can take place near a time there's justice argument for that, but of course it may extend the inquiry. I don't think the council have objection to further written evidence, but as with any inquiry, it would, presumably be in the form of a proof with perhaps statutory declarations attached. But as with any inquiry, the council would need to consider whether to submit a rebuttal proof.
Yeah.
Now, the usual situation, and my advice to clients generally is unless you really need to do it, don't do it. It's just going to annoy the inspector. That's so it doesn't mean to say that rebuttal evidence will necessarily follow, but if it's considered necessary, then yes, the council would want to submit rebuttal evidence.
Yes. All right. Now, although what we haven't bottomed out anyway is actual timings. Having listened to what's been said, although I accept that whilst Mr. Telford's circumstances have been extremely difficult over the last 18 weeks plus, he could have requested a postponement at an earlier stage. I accept that is the case. Nevertheless, it's not something over which the appellant had control, and I also accept that as a result of these circumstances, the appellant hasn't had the proper opportunity to consider all the evidence and to take advice on it. And whilst it does lead to inconvenience for everybody concerned and to the council, it causes delay to the proceedings. To proceed now, I believe, would result in injustice to the appellant because they wouldn't have had a proper opportunity to put their case effectively. And although it's something that I have been very anxious to avoid, I think for those reasons, an adjournment is the right way to proceed in the interests of fairness. Mr. Telford has made it clear that he's aware of what the consequences might be in terms of costs, and I don't need to say any more about that at this stage. But I think not only for the reasons I've just given, but also because there is considerable uncertainty about how this inquiry is to proceed, what evidence is going to be given, and in what format, in what forum, whether it's roundtable session or whether it's formal cross-examination and so on, that it's actually quite difficult at this point to predict how long the inquiry will take if we proceed now, and therefore it may be that it would have to be adjourned in any event. And with all those things, taking all those things into consideration, I think it would be better to have a longer adjournment and to put in place mechanisms which at least give us the fighting chance to proceed on a more efficient basis when we resume. And I will come back to that, but we can talk in terms of deadlines for any submission of any further written evidence, a deadline for rebuttals from the council, if so advised, before we actually resume. There may also, within that process, be the opportunity for a more focused statement of common ground to narrow issues further still. That does leave us with the difficult question about when we are going to resume. I don't know whether the parties have actually considered availability, and obviously there's my own availability to Mr. Telford, you've indicated that obviously it's not just you, it's witnesses to bring it to take into consideration as well. Have you, beyond this 3 weeks that you have indicated, do you have other dates that you know you need to avoid after that 3-week period?
At this stage, no, because obviously the circumstances I've not been able to book anything or plan anything too far ahead in the future. So beyond 3 weeks, I will make myself available for whatever occasion.
And do you have any information about witness availability?
I understand that beyond the period that I'm available, other witnesses will make themselves available at all times. Certainly that far ahead, Colin Steele will be available. It may be virtually, but he will be available. Timings, obviously he'll be about just to go ready to bed, but I think they're about 8 hours ahead, I'm not quite sure, but certainly he will be available anyway.
Within all this, Mr. Lighthead, is the other issue about whether the inquiry resumes virtually or face-to-face. Mr. Telford's expressed, I mean, it can be a blended event. Obviously, Mr. Steele is unlikely to attend from Thailand, so it's possible for some witnesses to give evidence virtually and others to be face-to-face. Is your preference, Mr. Telford, still for a face-to-face event?
It always is so, yes. But having caused the problems, obviously I'm in everybody else's hand in that respect.
Mr. Lighthead, do you have any views on that?
Well, so I think in general terms, a face-to-face event is always better. We learned in the pandemic that a virtual inquiry is possible and works well. So I haven't taken instructions. I'll look at Mr. Hawley. I thought a blended event would be appropriate. Mr. Hawley is nodding.
Yes, I mean, I have to be careful. I don't want to sort of speak out of turn in terms of what the planning inspectorate's overall position is, but the bottom line is it's for the inspector to decide which is the most appropriate. But I have done virtual events where evidence is given on oath, and it's not always been satisfactory. Sometimes it's worked very well, other times it's created all sorts of difficulties. So my preference is for a face-to-face event, but there is no reason why some witnesses can't give evidence virtually, if you like.
So just on the face-to-face, if you decide that dealing with notice number 2, as we all refer to it, which is the buildings, if you felt that was better dealt with round the table, then obviously face-to-face will be ideal and far better in that respect. Sometimes having been involved in many informal hearings, inspectors sometimes prefer to adjourn the proceedings to the site itself, which may be helpful to you, it may not be.
Well, yes, I mean, it's interesting. We start putting all these different procedures together, but although it would be a round table session, it would still be an inquiry, and wouldn't adjourn an inquiry.
Okay, I understand. Yeah.
To the site.
I have done that once though with mugs of tea with closing submissions around the appellant's kitchen table, but only.
Right. Okay.
Yeah.
All right. That the other thing about all this, Mr. Lighthead, is that certainly if there's a longer adjournment, then I see no reason in principle why a round table session should not be appropriate for appeal B. So there is that advantage.
I mean, if after considering it, so you take the view, I mean, it's because of the change in the rules a couple of years ago, there is this flexibility now. I mean, for instance, a 5-year housing land supply, you might have cross-examination on the policy basis, but not on the disputed sites. So even within a topic, there can still be flexibility. So as you consider the matter and the evidence, whatever comes in, you feel that cross-examination would assist you on a particular matter. It just seemed to me yesterday, looking through this detailed curtilage evidence, that cross-examining for 3 hours on different plans over time perhaps wasn't the most efficient way of doing it. I mean, Mr. Telford, I'm sure would enjoy that, but you may feel that a round-table discussion of that sort of evidence would be preferable.
It may be. I mean, it's just obviously Mr. Telford would have would give the bulk of the appellant's evidence in relation to the issue of curtilage and so on, but it's not entirely divorced from factual issues about how has the land been used and occupied. And Mr. Telford may not be the person to give evidence on that, and you may wish to cross-examine the appellant on those particular issues. So it's not, it's not entirely straightforward. It's not entirely neat, is it? And you can say, oh well, in ground B, appeal B is entirely suitable for round table. So it is tricky, but we at least have the opportunity to actually consider this. But
one thing I would say, sir, is with the humble advocates in mind, I think if there is to be cross-examination, they need to know before the day.
Certainly,
because they need to, just as you need to prepare questions, so do we.
Well, I think what I would do, I'm sorry this is all a bit rambling, but we're just edging away towards a solution, if you like. But I think what I would do is I would indicate that in principle, I'm happy for the appeal B to be dealt with by way of a round table session. But of course, once you've seen the further evidence, you may take a different view. So it wouldn't have to be fixed in stone, but I think the starting point would be a round table session for appeal B. I think that would be my preference at this stage. I will set all this out in writing after I adjourn, but I just want to make sure we've got these various things covered. And obviously the reason I asked about face-to-face is because then we're not just concerned about when advocates and witnesses are available, but we need a venue to be available.
And yes, and there's also the matter of closing submissions. It's always difficult on a one-day inquiry. The old way of doing it was that you just do it orally. Now inspectors like written closing submissions, and you do need time to prepare those.
Yes. You see what. Let me tell you my thinking on that. I don't generally like just taking closing submissions in writing because I nearly always have something I want to clarify with the advocates. And I also think that closing submissions are actually quite an important part of the public inquiry process. And so when people have sat, particularly when it's a multi-day inquiry, people have sat through, heard all the evidence, and then they get deprived of the opportunity to hear the closing submissions on both sides. So my preference is for closing submissions not to be in writing. But again, the last inquiry I did, everything was face-to-face except closing submissions were given virtually. So people had an opportunity to hear them. There was a time available for the advocates to finalise closing submissions before I heard them. So there's a number of ways you can deal with it. I will often, if it's a 2-day inquiry, I will do the site visit at the beginning of the second. If all that's left is closing submissions and a site visit, do the site visit and come back and hear closing submissions. So there's some opportunity. But also, having done some advocacy myself, albeit many years ago, I do appreciate how difficult it is when the inspector says on a one-day inquiry, can I have closing submissions in writing? It's not,
so for instance, yesterday, so I spent a considerable amount of time writing closing submissions, assuming it was going to be a one-day, because of the possibility of a one-day inquiry. So I think if a direction could be made in advance of the next meeting.
Normally I say closing submissions in writing if possible.
Yeah.
And I will then organise things, facilitate that so far as I can. If it's not possible, it's not possible. I mean, you're not, and also I have some doubt about the value of closing submissions that are written before the evidence.
I mean, I normally leave bits. So the ground D. I mean, without giving too much, I've left bits where I can add in. What happened there, and there's some legal discussion on curtilage. I will say to everyone, I referred to another case called Hiley, which doesn't add anything new to Blackbush. I can send it to Mr. Telford if he wants it, but it does have a helpful summary of Blackbush in it, things of what you can and what you can't do when discussing curtilage, and there's a bit of that.
Now, and there'll need to be probably another adjournment whilst we actually consider dates. But does the council have? We've got an indication from Mr. Telford that any time after 3 weeks, perhaps excluding Christmas Day and New Year's.
I was just about to add that. Yeah.
A fair game. But do you have? Because before I start looking at my availability, it'd be useful to have some idea about the earliest point at which the council might be available, advocates, witnesses and venue.
Yeah, are we looking for 1 or 2 days, sir?
I think it would be safest to say 2. If we finish sooner than that, great, but it's safest to say 2. I haven't seen, obviously nobody's seen this, what this extra evidence, further evidence might be.
So, sir, in terms of our room availability, then the next free 2 days that we've got is the 1st and 2nd of December. And that's in the council chamber if we're intending to meet in person.
Let me just have a look at my. We have a new system now that what was called the old chart system was very easy. What we have now is not so easy. So bear with me.
Apologies, I've misunderstood. It's actually the 21st and the 22nd of December.
Oh.
Next 3 days. So yes, alarmingly close to Christmas.
It is.
I mean, whether we can investigate another venue so that it's not at the council offices, we sometimes do that.
Well, it's just that I don't adjourn without saying what the date is going to be. If you think that you would be able to find another venue, then I can adjourn to a specific date to a venue to be advised. But if you're not confident about that, then I'd rather.
Yeah, without actually having a look at the availability of some of the other venues, it's very difficult to say.
So if it would assist as well, I'm pretty booked up until the second week of November, which isn't that far ahead of well, it's a bit of far, yeah. I mean, I could find 2 days before then, for instance, the third week of October.
But Mr. Hawley's saying the council hasn't got a venue before end of December anyway.
Well, so there's a date on Thursday and Friday, which is the 3rd and 4th of November.
I can't do that. I'm in the middle of a 6-day trial, I'm afraid.
The 17th or 18th of November. These are on Thursday and Friday, which we've discounted.
But realistically, sir, I mean, the reason, if the appellant needs time to put some evidence together, where are we now? We're this 4th, isn't it? No, sorry, November. Yes, that's about 8 weeks. That gives, I think, both parties time to. Yeah, 17th and 18th works for me as well.
That works for you. Well, on the phone, let me just check what's happening the following week, because I often say yes, and then I look at what I've got the following week. Right. Well, but strangely, remarkably, that hang on. Oh dear. Unfortunately, I've got a hearing on the 16th, but I'm almost certain it's going to overrun. So I'm afraid that's too risky for me. And it's at the other end of the country as well.
Yeah, we're then back to the 1st and 2nd of December.
Sorry, I thought there was some doubt over the 1st and 2nd of December.
Only because it's a Friday.
Oh, I see. Right. Yeah. Well, that looks at the moment. Sorry, I'm hesitating as I've got to decipher the information I get now, which isn't as clear as it could be. But that looks okay. 1st and 2nd December.
To get me out of my work Christmas party, I'll leave you to guess whether that's a good or a bad thing.
Yeah. Okay. Okay. So I'm just making sure I'm not storing up great trouble for myself because of what's either side, but I think that's okay. Right. Okay, so that would be the council chamber. You see, in terms of the number of days, we've affected, although we've done some useful things today in terms of talk about how things could go, we've not obviously touched on the evidence, and we've got 6 witnesses. So it has to be 2 days, I would say. And of course, we have the added problem of fading light in December when it comes to the site visit. So, right. All right. So on that basis, in terms of proofs of evidence from the appellant, commenting on counsel's proofs, Mr. Telford, if I specified 4 weeks for completion of those, that would take us to the beginning of October, and then let's just actually talk about dates. We're now on the 6th of September. So if I said proofs from the appellant by the 4th of October, rebuttals from the council, if so advised, by November 1st. That puts us back in the position which we should have been now, with proofs effectively being available 4 weeks prior to the inquiry. And if I could also ask for a statement of common ground by the 1st of November to include, because I haven't mentioned this before, but to include any suggested conditions in relation to the deemed application on Appeal B.
Sorry, I missed the last bit of that, sir.
A statement of common ground by the 1st of November of 2022 as well, to include a schedule of suggested conditions in relation to the deemed application on Appeal B. There is another point, so that we can get as much value out of this morning as possible. There is another point that I would like to touch on, though, and that is, first of all, before I do that, are there any problems with what I've indicated there?
No.
No, sir. And just one other point for the timetable. I'll take instructions, but I do, Mr. Tucker anticipates this already, but I do anticipate a cost application.
Yes.
Some time will be needed. And I assume you want that in writing, Lisa?
Yes, please. And certainly that will, yes, I mean, maybe we should factor that in at the moment, because might prompt cost application, but at the moment, you know at this stage the basis on which you want to make a cost application. So it would be helpful to have the cost application, because I'm just thinking about, the progress of the inquiry when we do resume the cost application. Well, would there be any, the cost application in writing by the 1st of November as well?
The difficulty with that, I'm not sure it's a big difficulty, but just thinking off the top of my head, the costs which will be wasted will be essentially anything from now there'll be conferences which will need to take place to review the evidence, to consider, draft rebuttal proofs, all that sort of thing, conferences in preparing for the next inquiry, and the costs incurred during the inquiry itself. Those costs won't have actually been incurred until the beginning of the inquiry, even if it can be predicted what they're likely to be. Now, of course, a set amount isn't determined by you for the money, but the principle of the costs for conferences and so on, it might be better on the first day of the inquiry to receive that in writing rather than or a week before the inquiry.
Well, the reason I said the cost application by the 1st of November is because then I could ask for a written response to that from the appellant. That doesn't mean to say that this can't be supplemented at the inquiry itself. I'm just trying to minimise the amount of time spent at the inquiry on costs. I think that it's the principles that are the principles in terms of unreasonableness, and the broad categories of expense that will be incurred, which I think are predictable, largely predictable. But anything that isn't predicted, well, you can say so on that during the inquiry. But
and of course that's subject to instructions, but it is something which has been raised before.
Yeah. So if I was to say written cost application by 1st of November 2022, written costs reply, because obviously you get, I'm not going to ask for your final comment on the cost application in writing prior to the inquiry, but a written cost response, if I was to say by the 15th of November, then that gives us a fighting chance to deal with that relatively quickly at the inquiry. I thought I don't want this is a situation where even 2 days isn't enough when we resume. Another adjournment will be pretty disastrous.
Yeah.
Right. Oh, and again, as I indicated earlier, at this stage, I propose to deal with Appeal B through a roundtable session. And whilst it's face-to-face, happy for some witnesses if necessary, particularly Mr. Steele, to attend virtually.
And And there's the issue of third parties as well to go in at whether you just want them to join in with the roundtable discussion or whether you want them to speak first. We're pretty aligned actually with you'll see a letter, a professional letter from
yes.
Forgive me the name of the
IBA planning.
IBA planning. I mean, whether you wish to hear from them first or whether it's just going to save time if they just chip in the roundtable. It is a matter for you.
Yeah, I mean, I think it would probably be better for them to chip in at in the round table. I don't want to be prescriptive about it, but it's it may be that once they've heard what you have to say about things, there's not necessarily a great deal to add. But I'm always flexible about timing when it comes to things like that. And as I said, you may come to, once you've seen further evidence, you may come to a different view about the roundtable session. But I'm just, as I say, indicating that matter of principle, I think it makes sense, given that was to be a written representation as appeared in the first instance. Now, unless there's anything else on those sort of matters, as I said, there was something else I wanted to just flag up, and that's the point that was raised in Mr. Hawley's proof about the fact that the building, the green building on the second notice, the subject of appeal B, is unfinished.
Yeah, there is the case law settled on that. Not everyone realises this, but a ground A appeal with a deemed planning application can only be considered for the state of the building when the enforcement notice is served. That's where Mr. Arnold came into difficulty. Yes. And I advise on this endlessly on the other side, where someone's almost finished their barn conversion and can't get their appeal in. That is the position we're in. So the appellant would need, you need to be satisfied with the condition of the buildings on the date the enforcement notice was served. And the appellant will explain to you, no doubt, why an unfinished building that looks like a dwelling house in the greenbelt, which is inappropriate development with no special circumstances, should be given planning permission.
Yes. Now, but one issue arises, another issue arises from it, and that's whether there's any need or purpose in correcting the allegation. I mean, the trouble we have is that an unfinished building is still a building in terms of the definition in the Planning Act. It's still a structure or erection. So.
Of course, so the point in Arnold isn't that no, it couldn't get planning permission.
No, I know.
But it just can't be finished.
No, it can't get. I can't grant planning permission for a finished building, and I've just got to decide whether it would be appropriate to grant planning permission for a finished building. Sorry, an unfinished building. But I'm just it's a technical point really, but whether the allegation should be without planning permission building operations comprising the partial erection of a building or the erection of an uncompleted building. As I say, the trouble with that is it's still a building, even if it's still a building. Yeah. So, Mr. Telford, as I said, the terms of the deemed application are prescribed by the terms of the allegation. Well, the terms of the allegation is a building, but the fact is the notice could only relate to what was there at the date that the notice was issued, and that date the building was unfinished. So do you accept that point, that I can't grant, even if I'm persuaded, I can't grant permission for what's shown on the plans that you've submitted. I can only grant permission for what was there when the notice was issued.
No, I fully understand that. Yeah.
Okay. Right. Is there anything else that I need to address?
I don't think so.
Right, thank you. So just to recap, and as I say, I will set this out in an adjournment note, but I'll adjourn the inquiry until the 1st and 2nd of December to resume in person at the council chambers. And in the meantime, the appellant to submit proofs of evidence by the 4th of October 2022, with rebuttals from the council if so advised by the 1st of November 2022, together with a statement of common ground, including suggested conditions, and together with written application by the 1st of November, and then a written response from the appellant to the cost application by the 15th of November 2022.
Okay.
And as I've said, assuming at this stage that we will deal with appeal B through a roundtable session, and that I'm content for necessary witnesses, particularly Mr. Steele, to attend virtually. All right, well, thank you very much I'm sorry we couldn't make more progress today, but thank you very much for your contributions. Happy Halloween, happy Guy Fawkes Day, and Advent. Right, thank you very much. Yes.
Sir, I can't go before I ask. The painting above your head, is there any relationship between the painter and yourself?
Well, you're supposed to think that. No, I'm afraid it would be nothing more than a scribble. If it was just a friend of mine saw that at some shop in London and decided they had to buy it for me, which was rather good. But this was before, I didn't put it up there for the purposes of virtual inquiries. It's been there for years.
Thank you.
I'm not a Renaissance man.
No.
All
Thank
right.
you very much, sir.
Yeah.
Thank you very much. Thank
All
you.
right.